What were you drinking then?
Twisted tea, Your Honor.
You just are continuing to consume alcohol. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
My point in that is he's highly intoxicated during these felonies. So that's certainly a concern if he were to be released even on a scram tether.
This defendant really walked into court thinking a few excuses would override failed drug tests. It's wild how some people treat a hearing like optional homework while facing serious charges. The prosecutor barely has to say anything. The facts speak for themselves. This is the kind of person who gets caught red-handed and still swears they're innocent. Let me know in the comments. Do people like this deserve another chance on bond? Or is zero tolerance the only way to keep the courtroom sane?
Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name?
There's a bond violation.
Yeah, no, I see it. Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do
To
that?
consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date. And then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
Right, Pickett.
I understand all of that, but my other problem is that given the other sort of mistest, I mean, what about you say the twisted tea on the 13th? What about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision. Can I speak?
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. I start talking. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I was.
So I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Rowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
The moment the prosecutor brings up that he was swinging a knife in traffic, the whole sympathy act falls apart. You can't downplay it as one drink, when people could have been seriously hurt. This is the kind of behavior that usually gets someone locked up immediately, yet he still thought asking for a tether made sense. The judge is clearly done entertaining excuses. You can see it in his tone. His attorney tries to soften it, but some situations just can't be sugar-coated. Watching the defendant realize his sobriety story isn't holding up is rough. I know some people think he deserves another chance. Let me know why, because I just don't see it.
The reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs a drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
If people have some concerns, if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bond.
This hearing is a perfect example of how fast things can flip in a courtroom. Addiction is real, but once you start putting the public at risk, the judge has no choice but to step in. A lot of people end up back in custody simply because they won't be honest about a slip before it spirals. The judge did exactly what the law requires. Protect the community first. It's hard to feel sympathy when the defendant kept pushing his luck until there was nothing left to defend. Watching him get remanded that fast should be a wake-up call to anyone who treats bond conditions like suggestions. Do you think the judge was fair, or should he have gotten one last chance?